Hello, everybody. Welcome, welcome. It's another edition of the Unfiltered Tea. How are you? How has your week been? I don't know if it's been this way for you, but Mercury goes direct soon next week, and it is like slamming the brakes on. It has just been a bit wild. So, hi, welcome. Let me know where you're coming in from, what you're sipping on this evening. We have a lot to cover. In theory, jury selection for the Kearney trial starts on Tuesday. So that's going to be a lot. Are there going to be more motions? Probably. Am I going to try and cover them? Yes. But housekeeping scheduling. Um, I have this Sunday with you. I have next Sunday with you. And then there's going to be a gap. And I will try to catch up where I can, but health things. So there's going to be a gap. I don't know how long that gap is going to be, but stay tuned on all the socials. I will keep you informed. So tonight is going to be a little bit interesting because I have all of my timestamps written down old school, but where I have the timestamps written down for, the audio was not good. So we're going to give it a try, but we might not, we might have to switch feeds. I think I have another feed that's a little bit better, but it also throws all of my timestamps completely into the bin. So that's what we're looking at this evening. Welcome. I'm going to go ahead and run the intro. Nope. Hold the phone. What I am going to start with, just so that you have an idea of where we're going tonight, I think what we're going to start with is a follow-up to that other case, the one with Aiden Kearney, Karen Reed, Brennan's trying to get the text messages and phone communications between them and was their counsel, the one with the judge that we liked, whose name I do not know off the top of my head. They will tell us, I do believe. Anyway, we're going to start there because it's kind of nice when things don't. This case is so crazy, and there are so many things with it that make everybody go, huh? That it's kind of nice when there's a judge who is very even keeled, very fair. And so we're going to take a look at that, and then we will get into the other motions. I will try to zoom, but some of these things are going to be buffering. Important for where we're looking at the trial and the defense. And then what we are also going to take a look at, I'm going to try and go as fast as I can. What we're also going to take a look at is Karen Reed has a new defense attorney. Another one who was a non-deliberating juror in her first trial. Vanity Fair wrote an article on it. We're going to take a look at that because what? So, yeah. So let me roll the intro and then we will dive in with that first hearing with the other judge. And then we'll get into the other stuff and we will go from there. And yes, chat, please let me know if the audio, this audio seems fine, but let me know if the audio is terrible and we'll see if we can find another feed. Streaming is dynamic. And with that, intro. Hello and welcome to the Unfiltered Tea, a show where we say all the things you wish the newscasters said, unscripted and unfiltered. We talk about politics, pop culture, and courts, so pull up your soapbox, pour yourself a cuppa, and let's go. Let's go. Oh, and somehow in doing that, StreamYard kind of fixed things? Wow. Okay. Don't mind me. Tech updating real time. I made myself small before I had anything else to show you. It's like I said, it has been that. So, no, that, share. There we go. There we go. All right, I have them at normal speed to start with because this judge speaks at a pace that my brain can keep up with. So we'll see what other adjustments we need to make as we go. But let's get started.
Judge, this is 22117 and 23313, the Commonwealth versus Karen Reed, and separately the Commonwealth versus Aiden Kearney. Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please. Sure. I need to plug in because I believe we have parties on Zoom.
Okay, I'm sorry.
It's also my understanding that we're only here on case 0117.
That was also my understanding.
Okay.
Thank you.
And do you have the Zoom identification link for me, please?
I do. It's right here.
Thank you.
There's no passcode.
Thank you.
I should have zoomed. Hang on. Let's see if we can do this. We're going to zoom. Just
okay, Mr. Clerk.
There we go.
Judge,
off the case and identify the parties.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Well, okay. That's new. Sure.
Any cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
Hello, Your Honor. Timothy Bradel for Aiden Kearney. I see him on the Zoom for the record.
Good morning, Attorney Bradel. Good morning, Mr. Kearney.
And Mark Federer for Mr. Kearney. Good morning, Your Honor.
Good morning, Attorney Federer.
And good morning, Judge. Attorney David Yannetti for Karen Reed, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Reed.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed? Doesn't seem so.
No,
okay. Folks, we are here on two related matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the three categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Reed during the time frame in question with regard to these three articulated categories be produced. However, subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that, one, there are, in fact, a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Reed's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order did not specifically exclude from production communications between Mr. Kearney and Ms. Reed's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
That is such a brilliant way of being like, you said one thing, because Brennan says a lot of things. And then this judge is like, but you said a thing, and that is not what I am looking at. So I'm going to give you the benefit of the doubt. Brennan?
May I?
Yes, you may.
I think there are two separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Brado, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
Yeah.
I don't doubt that you asked that if that is what happened, but that wasn't my...
Brennan, sir, that's what we all watched it. We all watched it. Sir. Really?
answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other.
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client.
I have never encountered somebody before in my life where I believe them less when they're like, or I misunderstood. Privilege
between Mr. Kearney and his attorneys, Mr. Brado and Mr. Betterow.
Okay, well, we all agreed, counsel, that those in fact would be privileged communications without question.
Of course.
So let's turn to, if you would, the second issue, which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Brado. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy to Mr. Kearney. And then Mr. Brado responded, well, it's a little more complicated because we know he was under investigation along with Ms. Reed without any resultant charges, so we would contend that does not fall under the umbrella. After more questions by the court, Mr. Brado answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Betterow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Betterow attempted to file an appearance on behalf of Ms. Reed. And in that, there was a supplemental motion, and it's docket 549, on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly.
Yep.
And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant,
I don't believe you. You've asked for it. Now you're sitting here saying you don't want it unless it's pursuant to. Trying to keep up with him and what he's actually asking for is wild at times. We can continue. I'm going to let him go just a little bit longer. And then in the interest of time, we're going to skip ahead to the actual Karen Reed part. But I wanted to, hey, internet, can we file a motion so that this judge can this judge just take over Karen Reed's case? Because I feel like we'd all be happier.
and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date, but those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043, in that pleading, it is set out by the Commonwealth's pleading that there is, in fact, information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823, when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys for Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that.
If you don't watch a lot of court like me, what this basically means is that if Kearney is talking with Jackson or Yannetti or Ms. Little, that is not privileged information just because they are counsel for Karen Reed, but they are not counsel for Aiden Kearney. So can this get messy? Yes. Is this trial already a hot mess in July? Yeah. Yeah, it is. So I still haven't quite sorted out how this all parses out. I think we are going to skip ahead at this point. I will give Attorney Bradel just a smidgen more time to clear a couple things up, and then we will leave this and move on because there is a lot to cover. And again, timestamps and things. So
There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this,
something to be aware of.
Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that the only communications that are on the table here, so to speak, are communications between Mr. Kearney and Ms. Reed.
I'll stop you right there, Attorney Bradel, because you
lawyers
raised an excellent point, and that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Reed that may also include members of her defense team. So it is my belief that is what might be at issue, but I will probe further of 88 Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, that the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we're privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Kearney and Ms. Reed regarding witness intimidation. There are none. So that there should be exactly zero documents or texts or emails that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that. And we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It can't. It doesn't. It cannot comply with the order. Your order said Kearney and Reed, not third parties that may or may not have spoken to Reed. And these are things that are privileged among that team. So this is a can of worms that the court did not open by any stretch. And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate, in particular because these two prosecutors are in different positions due to a conflict of interest, an expressed conflict of interest that has been identified and supposedly acted on by District Attorney Michael Morrissey. So
That's the spot where we're going to pause because to move on to the next one, because yeah, I did not know that until this hearing, that Cosgrove and Brennan are supposed to have a wall between them when it comes to these two cases because of an express conflict of interest that is known by the prosecution. So this feels like, with most things with this case, like they're trying to go in a side door instead of in the front door. And I apologize, my in-ear is driving me crazy. So yeah, that is they go on for a bit to discuss the conflict of interest and things like that. So I love this judge. He is wonderful. He keeps the court moving along. And he treats both sides fairly, which frankly makes the defense team better attorneys, and they're already pretty good. And it rattles Brennan, and I'm here for that. So now we're going to jump ahead. This is the one where the audio might be via potato. And if it is, I do believe I have a backup. Swoop. I need to swoop. Swoopity doop. All right. We're going to hope that this audio is somehow better on the computer than it has been for my other things. I am going to speed everybody up to 1.5 because otherwise we will be here until 10 o'clock tonight. And that's not how we want to spend our Sunday. We want to spend some time together, but we'll get to spending the whole evening together once trial actually kicks up. Kicks up? I have no idea where that phrase came from today. Anyway, so let me get started here. So let's see what I can. Nope. Aurora, share the screen. Streaming is dynamic. Okay. Nope, not that one. That's the one we want. Share. And Smollen and make me there. Okay. So we are going to start with the third party culprit defense. So, hang on. I need to embiggen because here's where we are at for those of you Words and I are clearly not friends tonight, and I work with words. So what the defense is trying to bring in is a third-party culprit defense. These fall into a couple different categories. There's the some other dude did it category, we think it's one of these people, but we don't know who category. And then there is, my client couldn't have done it, therefore somebody else did it. I think I have that right, but attorneys, comment, correct me. I'm happy to be corrected, because I am not one. So that's what we're looking at here. The defense team is like, hey, we've got third-party culprit here. As well as, and there's one other defense that is the investigation is so atrocious you can't possibly attribute guilt to the defendant because nobody's ever going to know who did it. This defense team is going at a couple of those different angles. And the Commonwealth is trying to keep out third-party culprit defense. So that is where we begin our day, is with the third-party culprit defense being argued over. I'm going to try and pick and choose where we zoom. Again, and I am going to start by starting them off at 1.5 speed. If I need to slow it down, I will slow it down. And if we need to switch court feeds, we'll switch court feeds. So I think that's everything before this.
Regarding the third-party culprit argument the other day, Ms. Yannetti, I see you did file something late yesterday, so I got that. I'm just wondering if either the Commonwealth or the defendant want to be heard on that.
The Commonwealth does.
Okay, so I'll hear.
Of course they do. I will say on none of the feeds can we hear the judge on this particular court day.
Your Honor asked for a proffer from the defense regarding third-party culprit. Alternatively, evidence that would be separate regarding third-party culprit aspect of Bowden. We received some information from the defense that does not distinguish whether their intention is that it applies to third-party culprit or whether it applies to a third-party culprit aspect of Bowden. Those concepts are logically and legally distinct.
These are the names that I described.
It is insufficient and inadequate for both third-party culprit and for any third-party culprit aspect of Bowden. Two different analyses, but the evidence is equally feeble for both. Relative to third-party culprit evidence, there are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit evidence. Not to iterate the law because it is clear, but there must be relevance, there must be a substantial nexus between the claims of the defense and the third-party culprit theory. They provided us 3 people that they identify as third-party culprits. It's helpful just for a quick synopsis of the history. In this case, prior to the first trial, the defense never identified a third-party culprit. At some point, the defendant herself said that they knew who the third-party culprit was, and recently, the position of the defense has shifted that they don't know and don't need to know. Now, the law accommodates specifically identifying somebody. It also accommodates general, but it has to have specificity in the complaint. It has to be a motive.
Pause. They don't. Now, maybe there's something in statute of, I'm going to try and game up the sound just a little bit and see if that helps. If it doesn't, we can also switch feeds. If Brennan, I'm going to let you continue, but they've brought you what you're asking for. Just because you don't like it doesn't mean it's not reasonable.
An opportunity and an intention. There has to be evidence that draws the correlation. It can't be bad character, speculative, or just putting out information that's negative towards a witness so that that can backdoor prior bad acts against a witness and be used for a different purpose. They identified one person, Colin Albert. And in their proffer, what they offer, number one, and it's important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up to January 29, 2022. Now, other than maybe on social media or in interviews with
Colin Albert, for those of you who missed the first trial, is the son of Brian Albert, whose house John O'Keefe was found on the lawn of. So, I don't know if it's him. He seems like a hothead teenager, but I'm not sure. I think it's their weakest argument or their weakest potential third-party culprit. Honestly, my own personal opinion. I get why they're following that. I get why the defense is following that, but I feel like they could just leave his name out of it and it'd be fine. I don't know. Maybe they know something I don't.
And national broadcast, there's no evidence of that. There's no evidence that's going to be admitted at this trial that shows there was a feud between Colin Albert and John O'Keefe. There is no evidence that there was any possibility between Colin Albert and John O'Keefe. There's no evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence of any motive, of any intention, or of any opportunity whatsoever. In fact, the evidence is that Colin Albert was not even at 34 Fairview at the time John O'Keefe arrived there on January 29, 2000.
But there is, though.
So simply saying it is not evidence, and an attorney should not be.
Sir! Let's see if my goat is louder, because we need the goat. Your entire argument is our witnesses said stuff, and therefore it's true. Apologize. Brennan makes me mad.
About an allegation that has no factual basis for them to then have to defend the accusation. The prejudice then seeps to the jury, and the Commonwealth is in a position to have to disprove a claim that had no basis to begin with. The second claim that they make regarding Colin Albert is that he had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face. There is no basis for those claims. There is no witness for those claims. There's no information regarding those claims. I understand there may have been a party where there was beer cans, but there was no Colin Albert. So to attribute a situation or incident to him, the defense would need some good faith proof, actual proof, fact, that this actually happened. And there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof is because
I mean...
So again, the defense asks for an invitation to simply cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor, and the government has to disprove it. That is not the cloth that third-party culprit is made from. Regarding the suggestion that there was some type of feud or tough relationship, I saw on a video that there were two radio personalities, and I have the clip, who spoke and met with Karen Reed, and during the conversations, at least they relate, that there was some claims about a drug issue, and according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. And so what we know is there is no history of animosity between Colin Albert and John O'Keefe. We know that there was no animosity between his family and John O'Keefe. The only event known is that at some point, Colin Albert's younger brother ran across John's lawn. Mr. O'Keefe supposedly...
Okay, this is all stuff to be worked out in trial. I am going to zoom you ever so slightly, sir. Because...
admissibility. Really, it seemed to be a backdoor way to tarnish his reputation and then find him with other people the defense would like to attack to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped, and inevitably, it turns out that picture knuckles on video.
We're going to zoom.
The gross generalizations that you see
there.
Would like to identify as a third-party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate and just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it. And even if it was so, has nothing to do with this case. Known as a bully. So rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination. Portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing.
Well, you're trying
They
to...
suggest, and I'm not sure what the basis for this is, that he was drinking quite heavily that day when he went to a funeral with Mr. Higgins and another person.
You don't know what the basis was? In the last trial, you had the Commonwealth had 40 some odd people come through to testify about drinking. Brian Albert was drinking from the morning all the way into the evening. Everybody at that house was drinking and driving according to every witness that the Commonwealth called.
It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just general inflammatory accusations about character. They say he was a trained boxer because when he worked out, he boxed and he was engaged in charity events, some dating back to 2003. By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general suggestion of...
Sir, I think it's the fact that it was his house And he never went outside. Ever. Ever. So I don't know if any of you have known law enforcement or anybody in that particular realm, but I don't know any the ones that I have known. Let me tell you, it's early in the morning and it's still dark and it's a blizzard and there's like 5 different cop cars and an ambulance in your yard. You're going out of the house. You're checking it out. The fact that he didn't is weird. Very weird.
Of strength and distorted into a hopefully perceived sense of violence that it has no root at all. No root. They went as far to say he was investigated by BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There was no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact. I'll say, even though it is off base entirely, it has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations by the defense.
Okay. He's going to go on and on and on. And I'm going to jump ahead to Yannetti. We're going to jump ahead to Yannetti's response.
Your Honor, the Commonwealth's motion raises 3 interconnected issues, not just 2. I believe that 2 of those were conflated by the Commonwealth. I'd like to separate them out. The first issue is the introduction or admissibility of evidence relevant to show that somebody else harmed John O'Keefe.
Right.
The second issue, which I think was conflated with the first, is whether after the introduction of such evidence, the defense is allowed to argue that a specific person or persons caused John O'Keefe's death. And then the third issue is whether the police properly investigated this matter in light of the information that they had or information they could have obtained or failed to follow up on to show that somebody else caused John O'Keefe's death. Regarding the first issue, which Mr. Brennan spent a lot of his argument on, there is ample evidence tending to show that somebody else caused John O'Keefe's death.
Yeah.
In our opposition, we have cataloged
I would agree with that.
each of the potential third-party culprits that we named the last time we were in court. Each one of them had a motive and an opportunity to harm John O'Keefe.
Mm-hmm.
The investigators in this case had evidence that pointed to Brian Albert. Brian Albert is a violent man. He was not only a boxer who punched people in the ring, he was also a violent drunk who sucker punched other police officers. Those police officers are on our witness list.
That's going to be an interesting day of trial if they get called. I have questions. I'm not sure I want the answers, but I have so many questions.
He's been investigated by the Boston Police Internal Affairs for having done so. There are many police officers listening to this argument right now who are nodding their heads. We've heard from many of them. It's undisputed that Brian Albert was present at the scene of the crime. It was his house. He claims to have been sleeping merely several feet away from where John O'Keefe's lifeless body was later found. There is evidence that John O'Keefe entered Brian Albert's house. The Commonwealth may not agree with that interpretation of the evidence, but it exists. It's a live issue at trial. At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up. He testified to that. He was at the hillside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard where Mr. Brennan claims that he was at the relevant time period. That day and night, Brian.
Now, to be fair, I have not been to this house. I'm not on the jury. Jury is going to get to go do a jury view. I will say my brain doesn't compute time and space very well. So there are some images where I see it and I'm like, how did nobody see it? And then there are other images that I see where I'm like, I mean, if it's cold and you're just trying to get to your car, I get how nobody saw him out there. Where I have a hard time with nobody seeing him at all ever, nobody seeing anything at all ever, is he was expected to show up to the house, and people have testified that they were looking for him to arrive. So that's where that argument falls apart for me as far as the Commonwealth goes.
Albert was attached at the hip to his close friend, Brian Higgins. This was the night that after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night. Higgins had expressed his interest, but it went nowhere. And it went nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him. She stopped returning his messages.
If you sat through trial number 1, you know that those are the cringiest text messages ever to go across airwaves. I am not looking forward to that trial day.
Brian Higgins was liquored up that night as well. They're both very large men. The court saw them on the video. Friends who drank the entire day and night. And they were waiting in the house for Mr. O'Keefe to arrive. Mr. O'Keefe ended up dead because he went to Brian Albert's house. After Brian Higgins left, Brian Albert maintained contact with him. At 2:22 in the morning, the two of them were exchanging phone calls to check in with each other just a couple of hours after Mr. O'Keefe was mortally attacked. Mr. O'Keefe had dog bites and/or scratches on his arm, consistent with the dog.
Yep.
Brian Albert had a large German Shepherd who had attacked and injured somebody in the past. It all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect. And I'm sure the court remembers the words in a text message of now ex-trooper Michael Proctor.
He had so much fun saying that. That now ex-trooper Michael Proctor. He had so much delight in saying that.
Lead investigator who's now been fired as a result, in part, of being biased in this investigation.
Yep.
I would point out also that when Mr. O'Keefe was in the house, both Brian Albert and Brian Higgins were unaccounted for, according to the testimony. With regard to Michael Proctor's words, he was asked specifically if the homeowner would catch any grief for having a deceased person on his front yard, and Michael Proctor said, nope, the homeowner is a Boston cop too. The message was clear. If you're a suspect, you get fully investigated unless you're on the right side of the blue wall. If you're a police officer, you get a pass. Now, in addition to the 2:22 a.m. phone calls with Higgins, there's other consciousness of guilt evidence implicating Brian Albert. And I would note, this is not something that Mr. Brennan addressed in his argument. He didn't talk about the consciousness of guilt.
He did.
Despite a massive police presence on his front yard, just feet from his bedroom, Brian Albert never came out to speak with investigators. And it's worth noting, it's worth stressing that Brian Albert was a first responder. He chose to ignore his duty to help somebody in need and instead stayed in his bedroom. And Brian Albert's dog, the family dog, a member of the family for 7 years, Brian Albert got rid of the dog, shipped it to another state, only after it was made known in court.
Commonwealth defends the internet would like proof of life of Chloe. I'm just going to remind you of that every time she comes up. The internet would like proof of life of Chloe also. She was a German Shepherd. Now, I happen to have a hound dog. My hound dog, uncharacteristically, does not alert really ever with barks. However, my own parents came into this house, their house, the other day, and she couldn't recognize the sound immediately, and that dog let out a very low growl. So if even my silent hound is like, hey, something's happening, I feel like Chloe would have done something. And by most of the accounts from the first trial, Chloe is not a silent German Shepherd. So, yeah. Excellent argument Yannetti makes.
The defense was alleging that the dog had been involved in the attack on John O'Keefe. We showed photos of John O'Keefe's arm in a public hearing where it was clear to any unbiased observer that Mr. O'Keefe suffered those particular wounds from a dog or animal attack. Brian Albert responds to that allegation by essentially divorcing his family from their beloved dog, whom they had had for 7 years and certainly considered to be a member of the family. In the aftermath of John O'Keefe's death, Brian Albert went so far as to send that family member to another state.
Well played, Yannetti. Well played. Lean in. Lean into how the internet feels about Chloe. Lean into that. Oh, I'm going to choke on
That's
air.
enough evidence to point to Brian Albert as a potential third-party culprit in this case. It's evidence that he had the motive, intent, and opportunity to hurt John O'Keefe. Brian Higgins is another potential third-party culprit. Like Brian Albert, Brian Higgins was present at the scene of the crime. He was there at the relevant time.
Yep.
In the house, again, unaccounted for. At the same time, John O'Keefe would have been there. Brian Albert had cause to back up his friend, but it was Higgins himself who was the one who had been flirting with Ms. Reed in the weeks leading up to January 29th. He testified that she kissed him goodbye after they had watched an NFL playoff game at a get-together not long before January 29th. He testified that she had visited him at his apartment after that, but he acknowledged that their text exchange and all contact between them ended, and Ms. Reed was the one to end the contact. She
I it was weird. And yeah, as far as motive goes, a dude like Higgins getting burned, I can see him having a hard time with that.
stopped responding to him. She no longer gave him any attention. So we come to January 28th. Brian Higgins sees Ms. Reed in person, but she's not alone. She's instead with Mr. O'Keefe.
Mm-hmm.
Ms. Reed and Mr. O'Keefe are affectionate with each other that night, and Higgins is there to see it, as is Brian Albert. There's evidence that Mr. Higgins wants Mr. O'Keefe to come to the Alberts' house that night. In fact, he appears fixated on making sure that Mr. O'Keefe went there. In the waterfall video, Your Honor, you will see
It's
that
a little
Higgins
weird.
motions to Mr. O'Keefe when they're leaving. And Higgins even texts him directly after that to make sure that he was coming. Then Higgins goes to the Albert home. John O'Keefe goes inside. Higgins is there waiting for him.
Okay, we're gonna zoom again because yeah, and then Higgins destroyed his phone and SIM card. I mean, Brian Higgins, there was a lot of rehoming going on. There was a lot of butt dialing going on. That is not normal for any of these things. So we're going to zoom ahead, let Brennan have a little more of a say. I love how my note here is sir. Yeah, we know. Yeah, that's my note. All right. Yannetti goes on and on and on because none of these guys are short-winded. There we go. Play. He goes on and he states his case for third-party culprit.
And the facts that aren't presented by the defense.
Sir, you almost never cite case law in anything that you do. So
We see in their motion there's a grand claim that there's extraordinary evidence that John O'Keefe went into 34 Fairview that night. That is critical because there is no basis to accuse somebody of murdering another person if they don't have the opportunity. In other cases,
the cops also never went into the house, so we have absolutely no idea what physical evidence was or was not in that house because the cops didn't ever go in.
the third-party culprit is not necessarily found at the scene, even in Finney. It's more than just a couple of derogatory words in Finney, as counsel knows. There was a neighbor who had an axe or a club. He was seen with blood, went home, washed his clothes.
Before I let him continue on this, I do have to say that when case law was cited, Yannetti chose case law where it was his case that was the case law, FYI. So if we're going to cite case law, Yannetti actually did, and it was cases that he'd been the defense attorney on.
Clothes, wholly irregular. And because of this irregularity and the timing, he was then asked by his then wife about the victim, and he made a number of derogatory comments about her, showing ill will, evidencing, tangentially, motive. And so, no, a third party does not necessarily have to be at the scene at the time the police investigate, but they have to be with the deceased if they caused the death. It's obvious. And so we didn't hear any extraordinary evidence, none. We didn't hear kind of good evidence. We didn't hear any evidence. We just have the bald assertion that the data forensic evidence will show that he was in the house. It didn't. It doesn't. They don't have a proffer. So there is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision.
I mean,
defense is
really? So
a story. Take a couple of facts. Someone's a boxer. They drank alcohol and convert it into a story. Is how they will try to portray these unsubstantiated facts at trial. They'll tell a story. It will divert the jury's attention. So they're not entitled to it. They're not entitled to it. Time-honored tradition, yes, but there are limitations. Silva Santiago was very clear about the limitations. This latitude is not unbounded. Each of these.
This is the point where I start to wonder if Brennan remembers that he is the prosecutor, not the defense in this case. Because he keeps making defense-based arguments, but it's as though the Commonwealth is his client. It just mm.
Limitations recognizes the admission of feeble third-party covered evidence poses a risk of unfair prejudice to the Commonwealth. I'm not lying. The Commonwealth should not be unfairly prejudiced. People.
You're not whining, Brennan. Brennan. That's kind of how it sounds, though.
Well, the Commonwealth should not be unfairly prejudiced because it is inevitably it diverts jurors' attention away from the defendant on trial and onto the third party. Essentially, it requires the Commonwealth to prove beyond a reasonable doubt the third party culprit did not commit the crime.
That's your job. That is your job. That your job is to prove that she did it beyond a reasonable doubt. Literally your job, sir. You have to do that. And if you can't, why are we here?
If there was evidence of third-party culprit, the defendant should be entitled to use it. In this case, there is not. There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. Certainly the defense can infer certain facts like getting rid of the SIM card in a way they want. And I don't begrudge that at all. There's different interpretations of it. I understand that.
Higgins took the SIM card, broke it in half, then drove it and the old phone, I do believe, to an army base where law enforcement has no jurisdiction to just scoop it out of a trash can, and he destroyed it there. I'd say that would indicate consciousness of guilt, but that's just me.
This was heavily considered in the federal investigation. And after that absolute thorough investigation, there were no charges. There was no evidence of third-party culprit. There were no indictments. And so, although we don't know the parameters of the federal investigation and we can only guess as to some of it, we know from what we
If you don't know, why are you guessing if you don't know?
did receive in review, it was thorough. And if there was third-party culprit evidence, we would expect that there would be a basis for it.
There
It's not
is.
bringing it in under voting. I don't defend that there was commentary in the officer's phone that was inappropriate. But that doesn't automatically create a situation where there is evidence that the police officers knew that there was somebody that should have been investigated.
I'd say that's a matter to be left up to the jury, Brennan, because the way I read Proctor's text messages, yeah, they decided that no matter what happened, nobody in that house had anything to do with it.
In fact, when Mr. Apple came downstairs, the testimony is the police officer was already inside his home. There's no evidence Mr. O'Keefe, first responders, was still outside that aid could have been rendered. And it's just something speculative. It's just piecing together different facts and telling a story. So inevitably, while I recognize the case law, there are plenty of cases that talk about third-party culprit should not be admitted if inappropriate. Commonwealth v. Stedman. In that case,
look, we have case law.
Was in a fight with a person at a campsite. And then later the defense supposedly went back to the campsite, a friend of this person, Royal, and used a knife to stab and kill him. And the defense wanted to introduce prior convictions about the fact that this supposed third-party culprit had attacked people at other homeless sites. Pretty close relationship. A person having a history of attacking people at homeless tent sites.
I'm going to pause you, Brennan, because this is a long day and we got to scoot. So, we're going to scoot ahead, and then Yannetti gives his case again. Where are we at? Oh, right. Commonwealth wants the motion for the footage from the documentary, all the raw footage from the documentary. And let's see. We are going to jump ahead to. We're going to see if this timestamp is correct. Yes, it is. Reasonably so.
May it please the court. The Commonwealth concedes throughout its motion, as it must, that the communications it seeks to intrude into are privileged communications between Ms. Reed and her attorney, Mr. Yannetti. 2 of the 3 instances of the communication they cite to are over 9 months old, and that's in 5 months old respectively. So you have 9 months ago, the Gretchen Voss statements, and 5 months ago, the Vanity Fair statements. But they waited until less than 2 weeks before the start of the trial to bring this momentous and potentially far-reaching and consequential motion.
Yep, it's a
The
problem.
courts are clear that they take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privileged communications this close to trial. The Commonwealth does not explain their delay in raising this issue this close to trial. With regard to the third communication, the HBO Max one, it regards the same event that is discussed in the first two. There is no addition of an event in the third one. So that third discussion, the docuseries, regards the same events that have been extant in the first two that have been extant for 9 months and 5 months. The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does.
And that's a little dig at Brennan, whose regular job is defense attorney. Yeah, attorney-client privilege. I will soapbox on this in just a second.
As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client, are canonical examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest privilege for confidential communications known to the common law. And this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context of criminal circumstances, the privilege has constitutional dimensions, as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Golden case 395 Mass at 502. And it bears underscoring the basis and the depth of the intrusion is a quote from the very case and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions, just one. Matter of a John Doe grand jury investigation 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that the potential is inconsistent with the traditional value our society has assigned. Here's a key point. In the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in not a factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to just stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is now routine, but I'm not going to give you this information, Mr. Brennan. I don't think it's appropriate for me to have so wishes tonight.
Since in this particular feed and on this particular day, no one can hear the judge, she lets Yannetti go through that entire argument. Not Yannetti, Alessi, go through that entire argument, only to interrupt him and say she's made a decision, which personally drives me kind of crazy because she could have done that before everybody walked into court. Truly, she could have. Just like she could reconsider her decision on the maybe dog behaviorist guy that the Commonwealth is pulling in, just like she could reconsider some other notions, and also like she could provide voir dire opportunities for at least some of these contested ones. She's done it for everybody on the defense side. I feel like the Commonwealth has gotten basically a free deposition from anybody they're worried about, and the defense hasn't gotten any of it. Any of it. And it is wild to me. Soapboxing for a moment, though. I am going to swoop, though, before we go back to everything, because I have a little bit of a soapbox. So, attorney-client privilege is pretty much as extreme a privilege as you can get, as I understand it. Again, not an attorney. Defer to attorneys on actual education of this, because I am not one. But and it can go beyond death too. So pretty much you can waive, if you're an attorney, as I understand it, you can waive attorney-client privilege, but only in instances where, like, your client has said, I have not yet done a thing, but I'm going to do a thing, and I'm in the car and I'm on my way, and that kind of a scenario. Runkle has some excellent scenarios in some of his videos for attorney-client privilege, but it's a big effing deal. And the fact that they are trying to get privileged communications to show consciousness of guilt, that is a problem, and not a small one. Hence why the judge was like, yeah, no. It's one of the few decisions she's made that's like, yeah, no. All right, let me take a look before I change things around. Because then I got sidetracked for other things because this week was a week. And let's see. Nope, aside from some entertaining words that I have that I will keep to myself on my own personal thoughts on Brennan. Let's see. Other stuff is about the other hearings. So, with that, I am going to swoop again because they had break and they came back. There are more motions to be decided. The motion to dismiss has failed. Because the judge is like, no, it's going to have to go before a jury. Fine, fine. That's what we're looking at there. So now let me swoop, and then we're going to pull up this Vanity Fair article about the juror that has now joined the defense team, because that it is such a wild thing to me. So we want to look at that, and then we will say goodnight and we will see what this week in court brings us. So let me remove that and let me bear with me for a moment, guys. Because I have fought with this, and it has been, let me see. That. Okay, that's going to do that thing again. Hang on, guys. I think I can fix it. Give me a minute. Give me a minute. I think I can fix it. I think I figured out how to fix it, but tech can be entertaining. Let's see. Now, if I do that, does that? No, stop. La la la. I should put on some music while I am fighting with tech. Does that? Wait. No. Yes? Yes! I did it! Okay. Now we're gonna see. I'm gonna bring me down here. No, I'm gonna bring me down here. And we're gonna see if I can make this. Oh, can I make this bigger? Bear with me. If I Nope, I can't make this bigger. Okay. I'll figure that out at some other point in time. But at least you can see this now. All right, let's see if I can. No. No. Ugh. I'll get there, guys. I'll get there. There we go. Finally. Finally. Okay. Hi. Streaming. Sometimes it's not as smooth as any of us would want it to be. Good thing I'm not a professional. All right. So let's read through some of this, at least some, if not all, of this Vanity Fair article. When Victoria Brophy George, I may not have said that name right, got the jury summons for the first Karen Reed murder trial outside of Boston 2024, she didn't balk. A Princeton graduate who grew up obsessed with the Supreme Court, interned with a federal judge, and got her JD from Northern University School of Law in Boston. George says she felt a civic obligation to participate in the oft dreaded enlistment. By the time she turned 34 last year, the employment lawyer had already served on 2 prior juries and acted as a foreperson. So we now know what she did for her law stuff. So that's a little bit different. So we're not dealing with criminal, but understanding the basic rules and stuff like that. So yeah, George had heard about Reed. The Massachusetts woman was all over Boston media as the prime suspect in the mysterious 2022 death of her Boston police officer boyfriend, John O'Keefe. Norfolk County District Attorney Michael Morrissey charged the then 42-year-old equity analyst with second-degree murder, manslaughter while operating under the influence of alcohol, and leaving the scene of a personal injury or death. Prosecutors alleged that in a drunken rage she had fatally backed her SUV into O'Keefe and left him to die in a blizzard. As Reed told Vanity Fair last year in a 2-part feature, she believed she was being framed as part of a cover-up involving Morrissey and Massachusetts State Police Detective Michael Proctor. Yeah, at this point, the evidence is just kind of wild. George, and here's where we get the twist. George, who joined Reed's legal team on Wednesday, was too busy caring for her 2 small children and grieving her mother, who died in 2023, to pay much attention and therefore qualified as a juror. I was able to be a juror because I believed that the state court system was going to give her a fair trial, she told Vanity Fair weeks before she joined the team. I've been trying to continue to believe in justice for a while. George is a conscientious rule follower. Once during the trial, after she drove past a Free Karen Reed billboard outside Gillette Stadium, she told Norfolk County Superior Court Judge Beverly Cannone to make sure she was on the up and up. The court assured her that she was. So she is such a rule follower. She drove by a Free Karen Reed sign and immediately alerted to the judge that she had seen that. This is me speaking at this point. Great, that's how it should be done. But wow. Okay. During 9 weeks of trial, she says that she and other jurors stretched conversation limits to avoid talk of the case. I'm sure that they did. I'm sure some cases you're like, yeah, the last thing we want to do is talk about the case. And then there are cases like this where you're just trying to get a linear anything. And I'm sure that a lot of these jurors were just anxious to talk to each other about the case. Which could not begin until deliberations, when another fellow juror began to openly criticize Reed. Before deliberations began, according to several jurors, she and her peers reported the person to Cannone. The juror they reported was dismissed. Yeah, the sidebar on that one was, I think that's the one that the sidebar was not great for the juror. For George, the fulcrum trial moment was when the Massachusetts State Police trooper Michael Proctor, former trooper Michael Proctor has been fired, The lead investigator on Reed's case read aloud the text messages he had sent his friends and supervisors only 16 hours into the investigation, including, quote, "There will be serious charges brought on the girl. She's a whack job. See you next Tuesday." I'm not saying that word. "Zero chance she skates. She's effed." I'm not saying that because live, YouTube, less than 2 hours in. I'm trying to be careful so it doesn't hide me. When someone on the text chain surmised that the homeowner on whose property O'Keefe was found would surely, quote, "receive some shit as well," I give up. I can't keep the expletives in my face. Proctor responded, "Nope, homeowner's a Boston cop too." Now, I heard that and was like, oh, so we're just deciding that because he's a Boston cop as well, nothing's going to happen. Great. Proctor later called the text unprofessional and regrettable. Yeah, that seems to be the tagline. It was unprofessional and regrettable. Maybe don't do it then. Okay. Jumping ahead, knowing he was the lead investigator, says George, and based on his own words, he had a pretty strong personal bias against the person in the defendant's chair. How do you ever trust the evidence coming from his investigation? That's what we all want to know. On the day of closing arguments, a juror who appeared to be sympathetic to the defense was dismissed. As revealed in court earlier this month, the dismissal was prompted by Massachusetts State Police Officer John Fanning, one of Proctor's supervisors, who Reed's lawyer Alan Jackson says has been on the text chain. While huddled at sidebar to discuss the reason for the juror's dismissal, Reed's lawyers Jackson, David Ionetti, and Elizabeth Little learned that Fanning, an investigator on the case working out of Morrissey's office, had that morning reported an alleged incident he had not personally witnessed that supposedly took place several weeks prior. Yeah, all of that was weird and problematic. There was no evidence presented at the time. As the court knows, Jackson told Cannone during a fiery exchange in his motion to dismiss argument on March 5th. There was no declaration, there was no report, there was no supporting documentation whatsoever. Over the defense's objection, this very potentially defense-friendly juror was then excused. I asked the court to take the evidence from Lieutenant Fanning. The court declined that invitation. Right. Cannone did not dispute Jackson's recollection of these events, but asserted that Fanning did not have direct or indirect access to the jury. To date, I have not seen any affidavits or anything, only Judge Cannone saying, well, he doesn't have access. But it seems like he might, but she says he doesn't, but there have been, we need more. Back to the article. In the state of Massachusetts, alternate jurors are selected at the end of trial. Several hours after the aforementioned juror's dismissal, the clerk magistrate wrote, okay, so I apologize to the folks I have talked with this about. I misremembered something. So the clerk magistrate rotated a box on a spindle and pulled out 2 tiles. He did not show the numbers to the court, which I have a problem with, but said they belonged to George and the other juror who had reported the critical juror to the judge. I have serious issues with the fact that you pulled out 2 tiles, said a couple of names or numbers, and never showed them to I feel like it would be the kind of thing where I'm searching for something, right? I feel like it would be the kind of thing where if camera is judge, right, that you would sit there and be like, there, I will show you, the tile, not, oh, I'll just take them and tell you and not show, like, how is a record kept of this? I somebody who's in Massachusetts courts on the regular, could you explain that to me? Because I don't understand how we do that. Okay. Now I need to find my place again. Okay. George I found it. George requested a sidebar with Cannone, of course, because attorney. And she recalls saying that their dismissal from the voting pool did not seem like a coincidence. Cannone declined to comment for this story, as she should. I mean, to be fair to Judge Cannone, like, now is not the time to get quoted in Vanity Fair. It might be good for you to watch, I don't know, any of the internet and see what they are saying, but probably don't get yourself quoted in Vanity Fair. Okay. George had hoped her legal skills could be helpful in the deliberation room. I lost my train of thought. As they had during a previous trial in which she served as foreperson. I'm sure her legal skills would have been very helpful in this deliberation room. In the state of Massachusetts, the judge chooses the foreperson based on a number of factors, such as attentiveness through trial and demeanor. Other times, the decision can be made arbitrarily based on seat number. If the judge happens to come across my little show, do yourself a favor and have it done arbitrarily by seat number this go round or something, because yeah, that would be wise. Um, to preside over the fate of Reed, a woman being charged with fatally hitting. We've covered this, Vanity Fair. Cannone selected a retired police officer to act as foreperson. Interesting choice, Judge Cannone. During trial, according to two jurors, the cop told his peers that he had been hit by a car. I'm kind of surprised he still made it to the jury, but sure. According to multiple jurors who have come forward since a mistrial was declared, there was confusion in the deliberation room about whether or not jurors could declare a partial verdict. I mean, it was very confusing. It seems that there was a lot of confusion. The jury instructions were hella confusing, and yeah. I am going to skip ahead because they were deadlocked on charges plural. The mistrial was declared. Reed has appealed the verdict. I'm now summarizing so that we can zoom through this. George has. Okay, so now let's skip ahead to some spots where it gets interesting again. George has 4 children under 5, including twin infant sons, and had no desire to come forward. She, quote, I waited for nearly a year after the mistrial, hoping the court system would work as intended to remedy some of the wrongs in this case. This is a non deliberating juror who happens to be an attorney going, this was extremely problematic. During the March 5th pretrial hearing, Jackson argued that Reed's case should be dismissed for reasons of, quote, extraordinary government misconduct, end quote. Yep, that had come from the motion, including Proctor's bias, investigative failings, the suspicion of jury impropriety, and the fact that some video evidence was withheld from Reed until January 2025. Yeah, they got brand new video evidence that they should have had in the first trial. On Tuesday, Cannone rejected Reed's request for an evidentiary hearing about the recently surfaced video, which I have so many problems with, which the Commonwealth has called an oversight and has denied Reed's motion to dismiss because, quote, the claimed violations here do not rise to a level that would justify the most draconian sanction of dismission, and because the defendant's constitutional rights can be fully protected in the coming trial. Sure. but it was how Hank Brennan, the special prosecutor Morrissey appointed to try the Reed this time around, responded to Jackson's allegation of jury tampering that compelled George to speak up. Brennan, who previously defended Whitey Bulger in federal court, suggested Reed's claims of, quote, extraordinary governmental misconduct, unquote, were dangerous and reckless, with the potential to cause the public to, quote, question the fabric of our entire judicial system, end quote. Brennan, sir, thems of us in New England already do for this. I mean, other reasons too, but this. George tells Vanity Fair attorney Brennan implied that the defense was responsible for causing sentiments of distrust in the justice system, yes, simply by questioning inconsistencies, inconvenient facts, and missing evidence. At that point, she decided if, as a lawyer, I was too afraid to stand up for what I believed in, who would? Even after the circumstances of her dismissal from the deliberating jury pool and the contested mistrial verdict, George had been hopeful when Brennan was assigned to the case. The respected Boston lawyer released a statement last fall saying that one of his core obligations was to make certain that Karen Reed receives a fair trial. He seems to have forgotten that, but that's just speculation and my observation. And the dignity and fairness that every defendant deserves in our criminal justice system. George says, quote, I was impressed by his background and naively thought that he would see the overwhelming evidentiary issues with the case against Karen Reed. At minimum, I thought he would encourage the Norfolk County District Attorney's Office to dismiss 2 of the charges given constitutional double jeopardy concerns. Not only has that not happened, but even when all of the parties have agreed and said, hey, can we continue this case? Judge Cannone is like, nah, I got a schedule to keep. I like my schedule. We're barreling ahead. It is truly mind-boggling. George was bothered by another seeming constitutional right at risk in Reed's case, her entitlement to the defense of her choosing. Earlier this month, Cannone denied Reed's request to add Mark Betterow, a former Manhattan DA, to her team because Betterow represents Aidan Kearney. This is where we finally circle back to everything, and this is the connection between Kearney and Karen Reed and Betterow and all of that. George called Jackson shortly after seeing the ruling to express her mounting frustration as Reed's second murder trial approached. George joked that she is still licensed to practice law in Massachusetts should Reed need an extra hand. Over the course of the conversation, the suggestion became less of a joke and more of a potential reality. Here's a fun fact. Because she's licensed in Massachusetts, it's not like Betterow, who it's up to the judge as to whether or not they can pro hoc vice in. The details of this an attorney would have to sort out, but yeah, she has the licensed in Mass advantage. And on March 26th, Reed filed a motion to add George to the team. And yeah, I appreciate George's final sentiment here. What happened to John O'Keefe was a tragedy, yes. But just because something is sad doesn't mean that the person in the defendant's seat is responsible. I can feel bad for his family and believe she's not guilty at the same time. Accurate. And the correction is that the article has been updated to reflect that the 4-person selected for the first trial was a retired police officer, not a retired Boston police officer, who told his peers he had been hit by a car, according to 2 jurors. Kind of depends, though, as to Boston PD, not Boston PD. Where are we talking on that end? So, that is where we are now. I have never I've watched a lot of trials. it is not something that seems even remotely common that attorneys are just coming out of the woodwork from multiple states to say, hey, pick me, I will defend you. It feels like, and they're all looking at the evidence, and they're, I mean, it is just wild to me. So, this is where we're currently at. I don't know what's happening. This case, if you pitched it to Hollywood, they would straight up laugh you out of the room because nobody would believe any of this. Um, but yeah, and then in keeping with the barrel forward no matter what happens schedule, apparently jury selection is going to start on Tuesday. So we are going to keep taking a look at that. I know that I put up a poll earlier. Aurora, you have a swoop for a reason to help you with timestamps. Which reminds me, it usually takes me about a week to get timestamps up. Timestamps are up on the last episode. And timestamps will be up on this one, but probably toward the end of the week because work this week for me is going to be like a lot. So, um, if I almost forgot again. Hi, welcome to the channel. Love having you guys here. Love replay crew. You guys are amazing. I love seeing the comments coming in. I'm trying to respond to all of them. Sometimes it takes me a while. If you made it this far and you haven't done it already, hit the like button if you want to know when I'm doing these and keep up on all things Unfiltered Tea. Hit that subscribe button, and usually we hang out on Sundays and we chat about things. Shows are getting longer. I try to keep it to an hour, but we're heading into court time. Shows are gonna get longer because court days are long. Um, and so we will take care of all of that. I'm gonna keep an eye on motions and things. As we head into this week, because I'm going to wager that there's going to be some attorney catfighting happening in motions civilly, because that's how they roll. But I suspect we're going to have some things to cover next week on this. If not, we might actually take a minute and maybe sometime this week, we will take a minute to sort of take the fire hose of news of what's going on in the rest of the world and get it down to at least a trickle, or at least be able to hang out and laugh about it for a little bit. So that is all coming. I don't know what capacity I'm going to have this week though. So keep a lookout with the socials and things like that, so that that's where I'm going to post those things most of the time. Oh, take a breath, Aurora. It has been wild. And yes, so I will be here next Sunday. Where's my calendar? I will definitely be here next Sunday, and then because I'm bad at calendar math. Oh wait, I have a calendar on my phone. Hang on a second. I have a calendar on my phone, people. I will be here next Sunday. The Sunday after, however, I'm probably not going to be here. But all of the channels that I have tagged in the description notes here, when I'm awake, I will be in the chat. We can hang out there and do those and good, good. Yes, yes, it is. So we'll see. I'm gonna try and get a couple extra things up. I don't know how I'm gonna be feeling Sunday the 13th. But we will see. There's gonna be some big stuff coming. I'll put up posts and things like that. We'll gather as soon as I am able to, but it might be a little bit. We'll see what we can do. And with that, everybody, thank you for being here. Thanks for hanging out with me. Thanks for watching this insanity with me and coming along for the ride. And we are here Sunday evenings, 6:15. Nope, my brain just buffered in real time. So that is my cue to say thank you so much for being here. Appreciate everything. As always, be well, do good, and remember to bark a lot. I will see you on the next one. Thanks for joining us for another episode of The Unfiltered Tea. Don't forget to hit that like button. If you have a story you want our unfiltered take on, go ahead and drop it in the comments, and we will see you next time.